Have you ever found the absolute perfect house with that one feature you just fell in love with, only to be told you have to get rid of it? Well, today we're diving into a fascinating, real-life story where that exact thing happened. We're talking about a homeowner, her dream driveway, and a battle with her homeowners association that went all the way to court. And this one quote right here from the homeowner Sally Magana, it just cuts right to the heart of the whole thing, doesn't it? You can feel her shock and frustration. For her, this wasn't just some pavers on the ground. It was a huge reason she bought the house in the first place. But for her HOA, it was a problem that just couldn't be ignored. All right, so how on earth does a driveway end up in a legal showdown? Let's get into it and break down this whole dispute. We'll start with the main players, the homeowner, Sally Magana, and her community's governing body, the Wynstone Park HOA. So in one corner, you've got Sally Magana. She's fighting for her driveway, her home's value, and really just trying to fix a problem. And in the other corner, you have the Wynstone Park HOA, who has a duty to enforce the rules for everyone in the neighborhood. And caught right in the middle, this paver driveway extension that, as it turns out, was causing some really serious problems hidden just beneath the surface, like drainage issues and even termites. Yikes. Now, this thing didn't just blow up overnight. It really started cooking in January of 2025 when Ms. Magana submitted a pretty reasonable request to fix a water pooling problem. But then the HOA denied her plan, so she went ahead and did the work anyway, figuring it was just essential maintenance. And that's when things really went off the rails. Almost immediately, violation notices and fines started showing up, and within just a couple of months, she felt she had no choice but to file a legal petition against her own HOA. What's so interesting about this whole case is that it all comes down to how you read one single document, the community's rulebook, officially known as the CC&Rs. And you gotta remember, these aren't just friendly suggestions. They are legally binding contracts. They tell you exactly what you can, and more importantly, what you can't do with your own property. Okay, so let's really dig into the arguments here. And we'll start by putting ourselves in Sally Magana's shoes. From where she stood, this wasn't about some fancy upgrade. This was about protecting her home from damage. And this quote from her contractor, Rita Elizalde, is pretty much the foundation of her entire case. See, the contractor testified that the pavers were sinking and literally funneling water toward the foundation of the house. In her professional opinion, the work they did wasn't some cosmetic choice. It was absolutely essential maintenance to stop long-term, expensive damage from happening. So here's the absolute heart of her argument. The project was a repair, plain and simple. Her crew carefully lifted up the old pavers, dug out the bad sand base and replaced it with solid granite, fixed the slope so water would drain away from the house, and then, and this is key, they put the exact same pavers right back where they were. So if you were to walk by, you wouldn't see any difference. To her, this wasn't an architectural change, it was just responsible homeownership. But of course, the HOA saw things, well, completely differently. So now let's flip the coin and look at their side of the story, where this wasn't maintenance at all, but a modification that was done without permission. The HOA Board President, Andrew Hancock, brought up a totally different angle. He explained that their decision wasn't just about how the driveway looked. A huge factor was ongoing complaints they were getting from a neighbor about cars parking on that extension, causing noise and blocking access. So for them, this was already a community issue. And this slide, right here, just perfectly captures the whole problem. It's the exact same project seen through two completely different lenses. The homeowner sees it as fixing a safety issue using the old pavers. The HOA sees it as replacing the entire base and changing the slope of the land after being told no. It really shows how a situation can be interpreted in two totally valid but opposing ways. So the HOA came in with a pretty solid defense. Point 1. They argued the work was a clear violation of their rulebook, which says you need written approval for any change or alteration. Point 2. They said the driveway extension was already breaking a design rule about how much of the front yard could be paved over. Add in the neighbor complaints and the fact that they have to enforce these rules for everyone, and from their perspective, they had no choice but to act. So, with two really strong but totally contradictory stories, the whole mess landed in front of an administrative law judge. You know, it's the classic setup, the individual homeowner versus the HOA board. So just think for a second, you've heard both sides. Who do you think the law is going to favor? The homeowner, who's just trying to stop termites from getting into her foundation, or the HOA, which has a legal duty to enforce the community's own rules? What do you think? The verdict came in, and the judge dismissed Sally Magana's petition.
Entirely. It was a decisive, clear-cut win for the Homeowners Association. A really tough outcome for the homeowner.
But why? How did the HOA win so easily when the homeowner's case seems so reasonable? To get that, we have to look past the emotion of it all and focus on the two key legal points that the judge's entire decision was built on. And the first big reason comes down to a really important legal idea called jurisdiction. Basically, it means a court can only make decisions on things it has the official power to decide on. It can't just weigh in on everything. Okay, so here's the legal breakdown. First, the judge said, look, I don't even have the power, the jurisdiction, to decide if the HOA violated a city ordinance. That's for a different court. But the real knockout punch was this. The judge found that the rule in question, CC&R 7.1, is a rule for the homeowner to follow. Since Sally Magana was the one who made changes without approval, the HOA wasn't violating the rule, they were just enforcing it, exactly like they're supposed to. And this right here is the bottom line, straight from the judge's decision. It all came down to the simple facts. The homeowner's own contractor admitted in testimony that they changed the base under the pavers and the slope of the driveway. And in the eyes of the law, that is an alteration that needed approval, which she never got. You know, this whole story is a huge cautionary tale for anyone who lives in a community with an HOA. It really makes you think, doesn't it? It shows just how important it is to know your community's rules inside and out before you start any project. Because as Sally Magana found out the hard way, the line between what feels like simple maintenance and what's legally defined as a modification can be incredibly thin, and crossing that line can have some pretty serious consequences.